My name is Michael Green. I'm the clerk of Green's List. A little bit of housekeeping to start with. The first is an apology. This morning we in fact advertised two presenters, Michael Shiel, who's here on my right, and Peter Lovell, one of our list members. Peter unfortunately is an apology as he's unable to be here this morning, but fortunately Peter and Michael prepared the paper together, and therefore Michael can and will cover the whole of the topic, and I think also, maybe more importantly, is a topic Michael has presented on many occasions in recent times, so we're very fortunate to have him here this morning. As you know, the topic is maximising your recovery of legal costs, and it seems to be a topic that's closest to the heart of all lawyers, so we hope we can help you this morning. The particular areas that will be covered by Michael are the new county court scale, with the comment it's more than a facelift, the cost court, how that's operated over its first 12 months of life and being, and cost orders and certification of fees. But beyond those specific topics, Michael's plan is to really have a wide-ranging discussion across the area of maximising recovery of costs. And I use the word discussion because Michael would like, and he thinks it's a topic which encourages interaction. Therefore, rather than having our questions at the end, when you might want to save them up, it flows better, and I think it's more helpful to you if, when you've got a question, as Michael's presenting, please put your hand up. We've got a microphone which we'll hand around the room so that everyone can hear the question, and it creates, as I say, a discussion rather than just a straight presentation. So please, if you've got a question, ask it at the time. Now, on to our presenter, Michael Shiel, who I've mentioned already. Michael is with Blackstone's Legal Costing. He holds Law and Commerce degrees from Melbourne University, and he practised for 3 years in commercial litigation with HWL Ebsworth. He's been with Blackstone Legal Costing for 3 years, and throughout his time as a solicitor and as a cost lawyer, Michael has been involved in a number of complex and difficult matters across all areas of practice, and therefore brings a significant depth of experience and expertise to his presentation to us this morning. Please welcome Michael Shiel.
Thanks very much, Michael. I'll just reiterate that if there are any questions, feel free to type up through the talk. It does tend to flow a lot better rather than me standing up here for half an hour lecturing everyone about costs. I should say from the outset it's a very impressive turnout. You're all either very dedicated or slightly insane to be here at 7:30 for a talk about legal costs. It is something that in a lot of practitioners the eyes glaze over when the topic's raised, and certainly from my own experience in private practice, it was you run the case, you win or lose the case, there's a costs order, a letter goes out to the cost consultant, and a letter comes back 5 or 6 months later with the result, and that's what's passed on to the client. There wasn't a hell of a lot of involvement certainly in maximising those costs, or even I suppose having the tips and knowledge throughout running the actual file to make sure that when it does get to that final crunch stage that the file's in an order where costs recovery can be maximised. As Michael touched on, the talk today, and I think we've got a break at from 8 to 8:10 just for people probably to restock on alcohol for a talk for an hour on coffee. Alcohol might be a better option for a talk on costs, and then we'll come back. So I will jump over the paper a little bit. It's more of a, I suppose, a skeleton as to what we propose to talk about. If there is any tangents that anyone wants to go off on, feel free. My slant is more, I suppose, towards commercial matters. That being said, I have had experience in personal injury matters, but by no means do I profess to be as knowledgeable in that area as potentially the recovery of commercial legal costs. So it will have probably that bit of a bent to it for the next hour or so in terms of recovering costs on commercial matters and also on solicitor-client disputes across all matters. I note that we do have a bit of a mixture of members of the bar and solicitors, so I will try and, I suppose, tailor it and talk about the main parts on the scale that relate to recovery of each of those items. It's something that probably the topics can be covered across the board and are important to all members of the profession, because if counsel's fees are the area that are likely to be attacked or that are reduced on taxation, it's more often than not the solicitor or the firm that wears the brunt of the shortfall between the actual commercial charge by counsel and what's allowed on taxation. The reason being because counsel's contracts are most regularly with the firm rather than the end client. So if the client challenges fees overall, the reduction comes off and it's the firm that bears the reduction overall. There's no breakdown to counsel suffering a reduction and the solicitor carrying a like reduction to professional fees that are charged. I think at the outset it's probably helpful just to run through the taxation process, what it is. I was lurking around the front of the room at the start of the morning and heard someone referring to the fact that Blackstone's is very close to the black arts and that's what costing might be classified as. It's not something that I haven't heard before and it's probably pretty close to the mark. It's not something that you learn at university, that you're sort of taught in the first few years of being a practitioner. Certainly you're taught how to bill under your own firm's electronic practices, but in terms of recovering on pursuant to scales and on party-party bases and solicitor-client bases, it certainly wasn't something that I came across before coming across to Blackstone. So the actual process of taxation is probably a very good place to start. So you win the case, you need to get costs. Ordinarily there's a process of negotiation where if it breaks down, the file ends up going off to a cost consultant for a bill of costs to be drawn. That is essentially every single thing that you have done on the file. So it's your discovered documents, all your brief to counsel has to be recalled and sent off to the cost consultant. All your briefs to experts have to come back. Every piece of paper that you've produced on that file needs to end up in your cost consultant's hands for the purpose of drawing a bill. I suppose the primary point I could get across today would be that taxation is very much an evidentiary process and is becoming more and more so since the invention of the cost court. It really does come down to an attendance that's claimed in a bill of costs or a letter that's claimed in a bill of costs being evidenced by your file. In terms of attendances, the file note evidencing the duration of the attendance note, the file note evidencing that there was enough detail in that file note for it to be reasonable for that telephone attendance to have taken an hour. So it comes down to a very intricate assessment of everything that the solicitor does every day on the file. There isn't really any room on the taxation for an overall view of the matter as a whole, that it was particularly important to the client, that it involved a large sum of money, that there were particularly complex legal issues involved. That area will come in to play later on when I talk about instructions of brief and the loading that gets put on bills of costs, basically as a recognition that the scale doesn't always, or very rarely adequately compensates a client who's been successful compared to a commercial charge. But in terms of the actual allowances for your letter, for your 15-minute attendance, they have to be detailed by the actual attendance notes that you take by the letters on the file. So we'll touch on that, and probably the best way, I suppose, to run and manage the file to make sure that everything you do is properly compensated. So the file goes off to the cost consultants, a bill of costs is drawn. Now, ordinarily, a bill of costs is broken into two compartments. There's a body of the bill and the instructions for a brief portion of the bill. The body portion is essentially what you call the guts of running litigation. It's your attendances on counsel, your attendances in conference, attending to instruct, counsel at hearing, all your letters to the other side, all of your pleadings fall into that category of the bill. And for each of those attendances, letters, there's a specific scale amount depending on the jurisdiction in which you've been awarded costs. So I think from memory this year's Supreme Court scale, 15 minutes skilled attendance is about $67. A clerical attendance, $40. There's composite rates for letters, drawing and engrossing on a folio basis, which is each 100 words, perusing on a folio basis, again each 100 words. And the work that you do is literally broken down into that minute detail. So if you have a letter in that's 4 pages long, you might say across the board there's 3 or 4 folios a page, you'll get 15 folios times the folio rate, which is $5 per folio, so you get $75 for reading that letter. That's essentially the process of quantifying your costs when it gets to taxation. So self-evidently, if that letter's not on the file, we can't claim it in the bill and we can't get it back. So again, it's vital that everything that you've done on the file is there. That's the body portion. The instructions for brief portion is what might loosely be termed evidence gathering material. So it's briefing your experts, it's attending on your own client, it's attending on witnesses to obtain statements, research into the case law. All of that sort of work comes under instructions for brief. The beauty of instructions for brief is that it does attract a loading. So As I said, the loading is essentially the court's way of recognising that the scale quite commonly doesn't adequately compensate a client for the work done. And for that reason, in the Supreme Court, for instance, you might get a loading of 80 to 100% on instructions for brief. Now, when you break that down into each item, instead of getting $67 for your 15 minutes, you're then getting $134 for your 15 minutes, which roughly works out across the hour to a bit over $520 odd. So it's a hell of a lot closer to the actual commercial rate for legal fees than the pure $67 that you're going to be allowed for body items in the bill. So for that reason alone, instructions for brief tends to be the largest section of every bill of costs that we draw. That and counsel's fees, which is something that I'll touch on, and I suppose being able to make sure that all the work that counsel performs can be compensated and that you get back at the end of the day if you're successful. But I suppose that's the very bare bones of what a bill of costs is. Our practice is to draw a bill of costs, send it back to you with an estimate of what we think it's going to tax at. No matter how well a bill of costs is drawn, it will always be reduced at taxation. So our job, I suppose, is to be able to provide you with an accurate range within which it's going to tax, so you can make an offer of compromise or have settlement negotiations in the confidence that if the other side's not willing to come within your range, you can run the matter at taxation, having put an offer of compromise in and recover the costs of running that taxation. Conversely, if we get served with a bill of costs by the other side, we draw a notice of objections. A notice of objections, in most cases, objects to about 80% of what's in the bill of costs, not because the bill's drawn particularly badly or because the work wasn't done. For one reason or another, it tends to be the process of a taxation. Parties object to as much as they can, are thankful for the things they get up on and write off the things that they don't. It does lead to a drawn-out process at taxation, but at the moment it is sort of the common format. So we'll draw the notice of objections, again provide a range back where we think the bill is going to tax, and that forms the basis of the parties' settlement negotiations. So once we've drawn the bill, it goes back to the client. If settlement negotiations aren't successful, a summons for taxation for costs is filed, which is in the Cost Court, which is 436 Lonsdale Street, so the Masters Court. We do actually have now our own courts on level 4. There's currently 4 main people, I suppose, presiding over taxations of costs. There's Cost Judge Wood, who was formerly the Taxing Master and Associate Justice, Judicial Registrar Goulet, who's an appointment probably within the last year, and then Registrars Kennedy and Devaney, who were from the County Court and came across. And as I'll touch on in a second, the Cost Court is essentially a one-stop shop for costs. So where before, if you're in the County Court, you'd go off to the County Court for a taxation, or if you're in the Supreme Court, you'd go there. Everything is now in the Cost Court, which is an arm of the Supreme Court. On that note, we are finding that matters relating to costs which arise throughout the course of a proceeding are being flicked off to the Cost Court for determination on a particular principle of costs. Some of the magistrates and judges are a champion at the bit to dispose of an argument as to costs in their jurisdiction. And given that we do have a specific jurisdiction to deal with those issues now, it does make sense, although again it probably does draw the process out a little bit. We push on from that point and the summons gets filed, and probably each month we get a call. We've just been served with a summons for taxation. It says we're due in court in 2 days. What do we do? It's not a cause for panic stations. A summons for taxation essentially directs everyone to go off to a call-over. Call-over is akin to a directions hearing for costing matters. It's essentially a room full of cost consultants jumping up when their matter's called to get dates, and that is normally as enthralling as it sounds. There's normally somewhere between 80 to 100 matters listed on the day. They've been known to run all day, although the lists are getting shorter and shorter. So it's essentially getting a date for the filing of objections and a date for the actual taxation, advising the court how long you think the taxation's going to run, that type of thing. So it's not a cause for panic if you get a summons on short notice. The summons is then served. One of the powers, and I suppose I'll push in now to the first page, which is the Cost Court. One of the new powers of the Cost Court is to order a costs matter off to mediation. So you may get an instance where the client's gone through 2 or 3 mediations in the substantive proceeding. They're now fighting for their costs and they're wondering why they're incurring even more money going back to another mediation on the issue of costs. The answer is normally that the parties are being told to go and do it. It's not normally by consent. Although that being said, they do have a very high success rate, and I think that's probably because When someone does an objections, they give an advice as to what it's going to settle in between. When someone does a bill, they give an advice. Cost consultants invariably know what's going to be allowed and what isn't on the bill, and the parties aren't that far apart to start with, so mediations do have a reasonably high success rate. Pushing into now, I suppose the cost, well, just to finish that up, I suppose if you do go off to mediation, it's not successful, you end up going to taxation, which is what essentially we're here to talk about today, how to make sure that if you get to that final step of taxation, the file's in a position where your cost consultant can sit there and argue that everything you did was reasonable or everything you did was necessary and proper, that the costs you've incurred are reasonable and they should be allowed as highly as possible. The cost court is what I'll touch on, and I suppose in terms of a practical impact for solicitors and counsel, it's more, I suppose, having the knowledge to report back to the client. There's not that many solicitors that attend taxations. It is beneficial if they do, because you can always obtain instructions as to why something was necessary, why it was reasonable, and if it's a particularly cost-sensitive case, or if it's the own firm's costs being challenged. If you really do want to maximise your costs, I would advise attending the taxation, because at the end of the day, the cost consultant didn't run the matter. They almost definitely don't have as intricate a knowledge of the matter as what you do. And so if instructions need to be provided as to why something had to be done, the practitioner is the person who's in the best position to provide those instructions. It's not an exciting process, but again, I come back to the fact that if you want to maximise recovery of costs, attending to instruct is a good idea. And as I touched on before, it's a matter of sitting through the file, showing every letter, showing every attendance, justifying that it was necessary and proper or reasonable, depending on the test under the order that was made, and I'll touch on that in a moment with respect to the different orders you can obtain throughout or to go to taxation. The cost court, there's a quick blurb there on page 2, but I suppose I'll just hit on the main regulatory changes that have had an impact. The first one was the mediations that I touched on. The other one, I suppose, is the appeal process from decisions in the cost court. Where one of the registrars sat on your taxation, your appeal mechanism is to a judicial registrar or cost judge Wood. Where cost judge Wood sat on the first one, you're back before Wood on the review. So unless, I suppose, you feel a grave error was made or something new has popped up to support your argument, the prospects of having it overturned are probably slight. If you want to then review the review, it's off to the Supreme Court and before a judge who's normally Justice Beach from my experience. That has to be done within 14 days of the taxation, so you need to get your notice for review in. I suppose the other main thing I'd touch on would be the assessment process has now been set up. It's akin to the federal court. I'm not sure how many of you have had a bill go through the federal court, but essentially you file your bill in the federal court and an assessment takes place almost on every bill, which is a registrar of that court sitting there and going through the bill and essentially providing the parties with a notice at the end saying, this is how much I think it's going to come to. If the parties want to challenge that, they have to move that amount in 15% by their favour, or they bear the costs of pushing on beyond that point. The cost courts essentially adopted a similar process whereby they have the power to conduct an assessment of the bill and send the parties a similar notice as to the amount they think it's going to tax at. There isn't a provision in that legislation, the 15% movement provision, but that issue was raised with Cost Judge Wood at a conference that I attended. His response was that there is still a discretion at all times on taxations to award costs either way. And if a party's been unreasonable in not accepting the assessed notice or assessed notice amount, haven't been overly successful in moving that amount but have incurred great costs in pushing on to a taxation, there is still the discretion obviously to award costs against that party. So probably as a broad rule of thumb, that 15% federal court rule should be adopted with respect to the assessments that come out of the cost court. The new county court scale is the next part in the handout, but I think I'll wait till after the coffee break to touch on that because it ties in very neatly, I suppose, with how to recover professional fees and how to maximise recovery of council's fees, because that is where, I suppose, the main change under the county court scale is. Just very briefly, the big liability factor, I suppose, with respect to the county court scale was a failure to obtain certification of council's fees. The county court scale with respect to council's fees was particularly miserly. I think at one point the scale allowance for drawing a document was $200 and something. I'm not aware of many counsel who will sit there and draw a statement of claim for $200 odd. So the scale much more adequately now reflects, I suppose, the commercial reality of running litigation in that jurisdiction. And it does allow the cost court some discretion as to how counsel's fees, or what amount counsel's fees are allowed at on an hourly and daily basis. So it does remove, to some extent, that risk of not obtaining certification. And again, very quickly, I don't want to talk about it 2 times, but the certification process is still important in the county court, because if you want to have counsel's fees allowed at a specific rate or allowed above the amount allowed for in the scale, you still need to have those fees certified by the judge making the order. So it doesn't obviate the need for certification altogether. I suppose it just makes the exposure, if you don't obtain certification, a little less. What I might do is flick through to the different bases on which costs can be taxed, which is party, solicitor, client, indemnity. There is a 4th one, which is solicitor-owned client costs, which is rarely ordered, but if you are able to obtain it and you're the party recovering costs, it's cause for celebration, because it is by far the most generous of the cost orders that you can obtain. It essentially entitles the cost court to tax the bill of costs pursuant to your costs agreement. A lot of people are under the, I suppose, misapprehension that that is very similar to an indemnity costs order. It isn't. Indemnity costs orders, first point of call, is always still the scale. So that's $67 for 15 minutes that I spoke about earlier. Even where you obtain an indemnity costs order, that is still the amount that's allowed for 15 minutes. You don't get $80 because you've had an indemnity costs order. You don't get, pursuant to your costs agreement because you've got an indemnity costs order. It still reverts back to the scale allowance for party, solicitor, client and indemnity. The only way, I suppose, that you can push beyond that scale is to get a solicitor-owned client costs order. The party test is necessary and proper. The solicitor-client test is reasonable, and the indemnity costs test is unreasonable. So the difference between solicitor and client is essentially that the onus is reversed. If you obtain a solicitor-client costs order, the ball's in your court to be able to prove that the costs you've incurred are reasonable. If you've obtained an indemnity costs order, the ball is in the other side's court to prove that your costs are unreasonable. On the party basis, it's what's necessary and proper. So on that basis, things that are termed loosely as luxuries throughout the course of running a litigation aren't allowed. It's essentially a test of how miserly could the litigation have been run and still have obtained the same outcome. It's somewhat of a fanciful test, because I'm not sure you want to be asking yourself that question on every activity that you perform, but it is the test when it comes down to taxation. And the difference between them from a practical perspective is probably, an example might be a number of attendances on the same person on the same day. On a party basis, what's really looked at is, did you have to attend, was it necessary and proper to attend on that person 4 times throughout the course of the day? So when you called them in the morning to obtain advice, they told you to go off and do something, you went off and did it, rang someone else, went back to them, something else came up. Or, alternatively, could one call have been made, all issues canvassed, and potentially one more issue coming back to revert to the client? On a necessary and proper basis, you're probably unlikely to get 4 calls to the same person on the same day, unless the file notes are particularly detailed and they justify that it was necessary and proper to follow that course of action. On a solicitor-client basis, you drop down a level in terms of the threshold, so you drop down to, was it reasonable? Was it reasonable in having conducted the litigation to act in the manner you did? That is, provide the initial question, get a response back, another issue is raised, you go off and find the information of that, and then go back to counsel or the solicitor. Yes? Oh, sorry, might wait for the microphone.
You seem to be focusing a lot on the solicitor doing what is or isn't necessary to do. What about looking at it from the other side, what the client does vis-a-vis the solicitor? That example you give of 4 calls during the day may have been instigated by the client as opposed to the solicitor. How do you deal with that scenario?
If it's your fees that are being challenged by that client at the end of the day, and the calls are originating from them, I don't think there's really an argument that they can make that they're not costs that you ought to have incurred. So in terms of challenging your own fees, I think you're probably safe. On a party basis, you're in trouble, because the test really is, well, should the other side have to pay for the way that your clients conducted themselves throughout the course of the litigation? If you've had a particularly over-exuberant client who's contacted you many, many times, well, it's highly unlikely that the other side, it's going to be deemed necessary and proper that the other side pay those costs. So I suppose the answer is that on a solicitor-client basis, in terms of your own fees, they can be justified. On a party-party basis and expecting the other side to pay those costs, it's highly unlikely you're going to get all of those. Anything else? So they're I suppose the three bases on which costs are awarded. We do see on a lot of correspondence the tagline tends to be, if you don't do what we want you to do, we're going to seek costs on an indemnity basis. The practical impact of that from, I suppose, a dollar perspective sometimes isn't that great. It really comes down, I suppose, the complexity of the matter and how big costs are overall. The reason being that I suppose the main kicker with an indemnity cost order is that loading that I spoke of before is higher. So instead of getting an 80% loading on your instructions for brief items on a party-party basis, you may be able to claim a 90, 100, 110% loading on the instructions for brief items because you have an indemnity costs order. So if it's a monstrous piece of litigation where costs to start with are high, the difference between multiplying that by 80 and 110% is enormous. If it's a $5,000, $7,000 costs matter, the difference between that percentage rise isn't that great. That being said, the other area probably, I suppose, where indemnity costs orders come in is that the attendances example that we gave. It's the test flips around where it's up to the other side to prove that it's unreasonable for all of those attendances to take place, rather than you having what can sometimes be the very difficult task of proving that every single attendance on that day was reasonable. We have a question up here, if we can get the microphone.
Thank you. Two questions, actually. In respect to the hourly rate for solicitors, if you have in your cost agreement the scale apart from the time spent by the solicitor, and you have it as time reasonably spent by the solicitor on work requiring the skill of a solicitor, and you have $700, for example, per hour, is that sufficient to get home against the client in the tax court?
The court will still look to the reasonableness of the agreement, and looking to the reasonableness of the agreement comes down to the reasonableness of the rate.
And that would depend on the practitioner's seniority?
It would, and I suppose they would also look at the reasonableness of that particular practitioner being engaged on that matter. If it was a straightforward
I'm thinking more of reading the letter.
Of reading...
Reading a letter?
Oh,
you're so talking... you keep the time?
Yep. Well, again, though, it does come back to the matter overall. I mean, you can't have a solicitor working on a particularly complex matter looking at a letter and saying, hang on, no, that's quite basic, I'll give it off to somebody else to read it, so we charge at a lower rate. So the court's not going to be unreasonable in that regard. They look to the practitioner who has conduct of the matter, and then the costs agreement is allowed on that basis. Obviously, the costs agreement has to tie in with the requirements under the Legal Profession Act, and that's probably a particular area of exposure whereby if it doesn't, you can see a reduction either at the end for failure.
But if you've got it in, you've got a chance of getting it.
Oh, absolutely.
All right.
Absolutely.
The second question is, what order do you get counsel to obtain to ensure that counsel's paid their hourly rate and their daily fee?
In the county court, you can get it certified. In the Supreme Court, you're at the will of the cost court, essentially. There's not an order. I mean, I haven't seen any, but I suppose the option would be there for a Supreme Court judge to specify that costs are to be allowed in a certain amount. I've never seen it. I don't think it would be an order that would be readily made, but that would be the only way I could foresee that counsel's hourly or daily rates would be allowed at a set amount in the Supreme Court. In the Supreme Court, the way we charge them in the bill of cost is pursuant to the fee, the invoices rendered by counsel, but the way that they're actually assessed is that the Supreme Court, I suppose for junior and senior, has a range that they consider to be reasonable for the particular year in which the litigation was conducted. They'll make a call on the complexity of the matter, how involved counsel was in the matter as to what hourly or daily rate they're going to allow across the board in the bill of costs. But in terms of having that, I suppose, fixed and taking it out of the cost court's hands, the only way I could foresee you could do that would be to obtain an order from the court, and as I say, I've never seen one yet. Let me know if you get one. We might... Nothing else? No? We might stop for the coffee break and let everyone refuel.